Let me ask you about the Supreme Court's decision in Lawrence affirming a constitutional right to be intimate among same-sex couples. Do you believe that was wrongly decided?
Senator, Lawrence versus Texas is a binding precedent of the Supreme Court.
Again, I'm aware of that, but I'm asking you whether you believe that was rightly decided or wrongly decided.
Senator, you're asking about my personal views.
No, I'm asking you about your legal views. I'm asking about your legal views. Let me ask you about another case. Do you believe that Loving versus Virginia, which affirmed an interracial couple's right to marry, was that wrongly decided?
Senator, my wife and I are an interracial couple, and so if that case were wrongly decided, I would be in big trouble.
Okay, so you do agree with the reasoning of that case, and you're willing to say that. I appreciate that. But you're unwilling to say that you agree that Obergefell and Lawrence were correctly decided. Why is that?
Senator, again, those decisions are binding precedent of the Supreme Court, and I would be bound to follow.
I'm aware of that.
So what just happened in that Senate Judiciary hearing was nothing short of eye-opening. Senator Adam Schiff, known far and wide for his political grandstanding, tried to trap a judicial nominee, Mr. Tong, in a corner using emotionally charged hypotheticals and woke ideological tests. But what Schiff didn't expect, that this nominee wasn't going to play his game. This was a tense, revealing exchange, one where Schiff tried to use the Constitution as a weapon instead of a shield. He grilled Mr. Tong on everything from the Emoluments Clause to same-sex marriage to interracial marriage, and tried to paint anyone who doesn't parrot his party line as dangerous. But here's the truth. What Schiff exposed wasn't the nominee. It was his own political agenda. Welcome to America Viewpoint, where we speak the truth, defend our freedoms, and fight for the values that made this nation great. No censorship, no woke spin, just bold, unfiltered commentary from real Americans who love this country. If you're tired of the lies and ready to stand for faith, family, and freedom, hit that like button, subscribe, and ring the Liberty Bell, because this is where the fight begins. Let's get right into it.
Mr. Tong, you just said that you're an originalist and a textualist. So let me ask you, the Emoluments Clause provides that no person holding public office shall accept any present of any kind, whatever, from any king, prince, or foreign state. Do you believe the language in the Emoluments Clause that says any present of any kind, whatever, means any present of any kind, whatever?
Senator, you are quoting the text of the Emoluments Clause, and I cannot dispute with the text of the Emoluments Clause.
So it would apply to any present, including an airplane?
It would apply to the president, I believe, your Senator.
And I take it as an originalist, you would accept that the founders would have never subscribed to the idea that a president in their time could have accepted a multi-$100 million gift from a foreign state?
Senator, the premise of your question implicates live issues in the public and pursuant to the canons of judicial ethics.
Well, let me just ask you, would the founders have believed that if a president received 100 camels from a foreign state, that was an emolument?
Senator, it's difficult to answer that question in the
Is it, though, as an originalist? Isn't it pretty simple? You've got the clear language of the Constitution.
Senator, one has to look at the language, but also the history surrounding the Emoluments Clause in order to discern.
I am looking at the history. Let me move on to another question. As an originalist, do you believe that the Obergefell versus Hodges decision affirming constitutional right to same-sex marriage, was that wrongly decided?
Senator, Obergefell versus Hodges is binding precedent of the Supreme Court.
I'm aware of that. Do you believe it was wrongly decided?
Senator, as a circuit judge, I would be bound to follow
I understand that, but that's not responsive to my question. Had you been on the Court of Appeals prior to that decision, would you have decided the case that way?
Senator, prior to Obergefell versus Hodges, there was a prior Supreme Court case addressing the issue, and I would have followed that case.
Well, would you have reached the same conclusion as the Supreme Court in Obergefell?
Senator, I would have followed binding precedent.
You're not answering my question. Would you have reached the same conclusion?
Senator, the conclusions that the two precedents reached were potentially in conflict, and I would have to follow the precedent that
So you can't tell us at this point whether you would have reached the same conclusion as the Supreme Court in Obergefell. So let me ask you about the Supreme Court's decision in Lawrence affirming a constitutional right to be intimate among same-sex couples. Do you believe that was wrongly decided?
Senator, Lawrence versus Texas is a binding precedent of the Supreme
Again, I'm
Court.
aware
and
of
I would be
that, but I'm
bound by
asking
that
you whether
precedent.
you believe that was rightly decided or wrongly decided.
Senator, you're asking about my personal views.
No, I'm
and as a
asking you about your
nominee-
legal views. I'm asking about your legal views. Let me ask you about another case. Do you believe that Loving versus Virginia, which affirmed an interracial couple's right to marry, was that wrongly decided?
Senator, my wife and I are an interracial couple, and so if that case were wrongly decided, I would be in big trouble.
Okay, so you do agree with the reasoning of that case, and you're willing to say that. I appreciate that. But you're unwilling to say that you agree that Obergefell and Lawrence were correctly decided. Why is that?
Senator, again, those decisions are binding precedent of the Supreme Court, and I would be
No,
bound
I'm
to
aware of
follow.
that. So is Loving. And you're willing to tell us that you believe Loving was correctly decided, but you're not willing to say the other decisions were correctly decided. That seems less originalist and more situational. Let me ask you this about your role in the brief in Moore versus Harper. This was a case involving the discredited independent state legislature theory, which would allow a state legislature, even in the absence of a governor's signature, to effectively overturn an election. Do you believe that the Supreme Court wrongly decided Moore v. Harper when it rejected your view?
Senator, again, Moore v. Harper is binding precedent of the Supreme Court. and
Yeah, no,
although-
I get that, but you're still not answering my question. So let me ask you a different way. If a state legislature decided after an election to pass a bill, even in the absence of a governor signing it, to throw out absentee ballots that were mailed prior to the election but arrived after the election, would it be your view that a state Supreme Court or federal court would have to allow the legislature to overturn the election, would be powerless to correct that effort to overturn a free and fair election?
Senator, Moore versus Harper states that state courts can review what the state legislatures have passed as a matter of the
No,
Constitution.
I'm aware of that. And my concern, though, is that your unwillingness to embrace the reasoning of these decisions means that where there is room, and there is room in all of these decisions, and most particularly Moore v. Harper, for you as a court of appeals judge to narrow these decisions, it sounds like you'll take that opportunity to narrow those rights. And in the case of Moore, which I agree with Judge Luddick, the most important case to our democracy in a century, narrowing that decision means empowering state legislatures to overturn election results, and I cannot imagine a more dangerous idea on the bench. I yield back, Mr. Chairman.
The hearing starts with Schiff honing in on Mr. Tong's judicial philosophy. Tong identifies as an originalist and a textualist, terms that should be music to the ears of anyone who believes in the Constitution as a fixed, foundational document, not a living, breathing one that morphs with every cultural whim. But Schiff? He pounces. He picks the Emoluments Clause, the section of the Constitution that says no one in public office can accept any present of any kind whatever from a king, prince, or foreign state. Seems clear, right? But Schiff asks, would that include a plane? $1 million gift? 100 camels? Folks, let's pause right here. These are the kinds of gotcha questions designed not to seek truth, but to make anyone look ridiculous. Schiff wasn't clarifying constitutional limits. He was painting Mr. Tong into a corner so he could later accuse him of being unethical, extreme, or out of step with modern values. But Tong doesn't take the bait. He sticks to the principle. He cannot comment on live issues that might come before the court. That's not cowardice. That's integrity. Because here's the thing. Judges aren't politicians. They're not supposed to tell us in advance how they'll rule. That's what judicial ethics demand. But Schiff, he doesn't care about that. He wants a litmus test. He wants political loyalty, not constitutional fidelity. Then we move to the heart of the hearing and the heart of the ideological war being waged in our courts. Schiff goes down a checklist of Supreme Court decisions that are near and dear to the left's cultural agenda. Obergefell versus Hodges, the the case legalizing same-sex marriage nationwide. Lawrence versus Texas, the case decriminalizing intimate relations between same-sex couples. And of course, Loving versus Virginia, the landmark ruling affirming the right of interracial couples to marry. Let's be clear, Schiff wasn't asking these questions out of genuine curiosity. He wasn't interested in Mr. Tong's legal reasoning. No, this was a loyalty test. Schiff wanted to hear the words, "Yes, I agree with these decisions. I embrace the values of the modern progressive left." That's not jurisprudence, that's politics. And Mr. Tong? He refused to play along. On Obergefell and Lawrence, he said what any ethical judge would. These are binding precedents of the Supreme Court. As a lower court judge, I would follow them. And that should be enough. But Schiff presses harder. Do you believe they were rightly decided? Not whether he'd follow them, but whether he agrees with them personally. And when Tong declined to inject his personal views, Schiff exposed the whole game. You were willing to say Loving was rightly decided, but not Obergefell. That's not originalism. That's situational. But hold on. Mr. Tong gave one of the most honest answers in the hearing. My wife and I are an interracial couple. If Loving was wrongly decided, I'd be in big trouble. Boom. Real. Human. Grounded. And yet, Schiff tries to spin that as a contradiction, rather than acknowledging the obvious, that some questions are ethical or personal and others are legal and constitutional. Schiff wasn't satisfied with Mr. Tong respecting precedent. He wanted him to pledge allegiance to the progressive worldview. Where's the respect for judicial independence? Where's the commitment to impartiality? You see, folks, this hearing wasn't about protecting rights. It was about controlling judges. That's the left's game. Redefine the Constitution, weaponize empathy, and force jurists to bend the knee to woke ideology. Then came the climax of Schiff's interrogation. Moore versus Harper. This is the case where the Supreme Court rejected the independent state legislature theory, which holds that legislatures, not courts, have the ultimate say in regulating federal elections within their state. Schiff paints this case as the end-all be-all for American democracy. He claims that if Mr. Tong has any sympathy for the theory, he must be a threat to free and fair elections. He even goes so far as to ask, if a state legislature passed a law without the governor's signature to toss out absentee ballots mailed before Election Day, but received afterward, could a court stop it? It's an emotionally charged scenario, but it's also completely hypothetical, and Schiff knows that. Mr. Tong does what any responsible nominee should do. He points back to the actual ruling in Moore versus Harper, which says state courts can review legislative actions. He doesn't speculate. He doesn't grandstand. He references the precedent and sticks to principle. But again, that's not good enough for Schiff, because Schiff isn't looking for restraint. He's looking for a promise that this judge would rule in a way that benefits his side. But that's not how the judiciary works. The whole point of the courts is that they're not political, that they interpret law, not twist it to fit popular sentiment, that they uphold the Constitution, even when it's inconvenient. And that's what Mr. Tong was defending, even as Schiff tried to tear him down. Let's not miss the forest for the trees here. This wasn't just a hearing. This was a cultural moment, a declaration of where the progressive left wants to take our judiciary, and a warning for every American who still believes in the rule of law. The left wants a court system that agrees with them on every issue, social, moral, and political. They want judges to affirm their worldview, not interpret the law. And they'll bully, shame, and interrogate anyone who dares to stand on principle instead of politics. But we see through it. We know that judicial originalism, the belief that the Constitution means what it meant when it was written, isn't dangerous. It's foundational. We know that following precedent isn't weakness, it's integrity. We know that respecting judicial ethics, refusing to comment on live issues, isn't evasive. It's responsible. And we know that when Adam Schiff and his allies demand that judges affirm every left-wing cultural landmark or be branded as extremist, it's not about justice. It's about power. So the next time you hear someone say we need balanced judges or mainstream nominees, ask yourself, balanced according to whom? Mainstream according to whose values? Because what Schiff wants isn't balance. He wants submission. And what America needs is courage. The courage to stand firm, speak truth, and defend the Constitution against all enemies, foreign and domestic. This is America Viewpoint, where we don't whisper, we roar. We stand tall, speak loud, and never back down from defending truth and liberty. If this message fired you up, smash that like button, hit subscribe, and turn on notifications, because the fight for America doesn't end when the video does. Until next time, stay strong, stay free, and may God bless the United States of America. Today's video was based on the Senate Judiciary hearing where Senator Adam Schiff questioned Judicial Nominee Mr. Tong about the Constitution, judicial philosophy, and precedent. Schiff tried to trap a principled judge in a maze of hypotheticals and woke ideology, but we saw through it. Because at the end of the day, what matters most isn't how loud they yell in D.C. It's how strong we stand as Americans.